263rd session of Legal Empowerment through Interaction lecture series. As the journey continues, and we thought we'll just slowly wind up because we thought COVID was taking a backseat. Now it is coming in different variants, different forms. Maybe we'll again be tied down to our rooms or homes for that matter. And maybe we might have to go back to that intensive sessions so that to keep our sanity in these trying times. But let us hope that Omicron or whatever variant may not create so much of problems as we faced earlier. All the same, today we have a wonderful speaker who had addressed us earlier also. That is Professor Dr. Rose Varghese, and the topic for today is a hot topic of current times. That is victim-oriented criminal justice system, the need of the hour. We are privileged with the presence of Justice V. Ramkumar sir, Justice Ramakrishnan sir, and all of you wonderful participants who have been part and parcel of this journey of discovery, interaction, and enlightenment. So today, when we talk about criminal jurisprudence, the initial thought would have been retribution or rather to punish somebody. But we used to lose sight of the victim. So to do the introductory remarks, may I request Prem.
Good evening, everyone. Today, we are on a systematic focus on the concerns of a victim to guarantee such victims some sort of sympathetic or subtle or sensitive delivery of the very service of criminal justice. Now, a victim-centric justice system that would seek to minimize a kind of a re-traumatization which is related with this judicial process. I mean the justice dispensing process. It can equally empower the survivors as engaged participants in the whole trial process. And it could provide the victims with some sort of opportunity to play a very significant role in seeing their traffickers being brought to justice. As far as India is concerned, under our criminal justice system, we know that victims were almost like insignificant in the criminal proceedings, except they being cited as witnesses. Now, unlike the accused, the victims had literally no role in the criminal proceedings. Either they are left to suffer the injustice silently, or they could seek some sort of personal retribution by taking law into their hands, if at all. Now, one of the earliest decisions of this topic, I would say, is the one by the then Chief Justice Y.V. Chandrachud, speaking for a three-judge bench, the famous Rudal Shah case, 1983 4 SCC 141, which ordered the state to pay a compensation at that point of time. I think it was 30,000 or 35,000 to the victim who was illegally detained for a span of 14 years, even after the court's acquittal order. Equally important is Justice Chinnappa Reddy's decision in Bhim Singh versus State of Jammu and Kashmir, 1980 Supreme Court 494, where we know that the state was ordered to pay a compensation of rupees 50,000 to the victim who was an MLA who was illegally arrested. Of course, these all were constitutional thoughts. Then Justice Jagannatha Reddy in Hari Singh's case, it was a 1988 decision of the Supreme Court, where the Supreme Court went on to consider Section 357, Clause 3 of the CRPC, and finally held that the court's power to award a compensation, it was rather intended to do something to reassure the victim that the victim is not forgotten from this criminal justice delivery system. And we have the famous Saheli case in 1990. Then you have the off-court judgment by Justice Verma, Nilapati Behra. You have Bodhisattva Gautam, applied during 1996. Many cases. And I would say, finally, I think it is in the Delhi Domestic Working Women's Forum case of 1995. That was a repetition under Article 32 of the Constitution, where the petitioner therein filed the writ to espouse the pathetic plight of 4 or 5 domestic servants who were subject to certain indecent sexual assault by some army personnel. And a 3-judge bench of the Supreme Court, speaking through Justice Mohan, called for the extension of the right to legal assistance to victims of the sexual assault, even at the pre-trial stages. Now, Professor Rose would cite more judgments, and I won't venture to cite more. But anyway, I need to cite one of the recent judgments of the Kerala High Court, speaking through Justice Devan Ramachandran, in the minor girl Devi Priya's case, ordering a compensation of 1.5 lakhs of rupees, that was during last month, for her being tortured by the pink police, despite the state defending the police officer's action. Now you have the Mallikarjun Kodagali's case of 2018, where the court literally accepted that under our criminal justice system, the rights of the accused would far outweigh the rights of the victim. And the court, speaking through Justice Matan Lopur, I think, not only called for the introduction of a victim impact statement in order to guarantee participation of the victim in the trial proceedings, but also the court reiterated the victim's right to appeal. Section 372 of the CRPC was considered by the court. Of course, there was a part dissent by Justice Deepak Gupta, but he attested to the majority view regarding this victim. And it was during 2020, as we know, Chief Justice Sharad Bobde, heading a 3-judge bench, he had an occasion to ask an accused who came up with a bail plea. He was accused of raping a minor girl, and the 3-judge bench had put a question whether the accused will marry her. And mind you, our own Supreme Court has discouraged these sorts of practices very heavily, for which I would quote the Shimbu judgment of 2014 by Justice Sadashiva. Now, whatever, after the Law Commission report during 1996, we know, then there was a Malimat committee during 2000, subsequent to which 2009 the CRPC has underwent certain notable amendments, of which we see Section 24 Clause D, there was a proviso was added. Then you have 157, there was an amendment. You have 357A, 357B, like that. So, even though all these amendments were there in the CRPC, still the ground reality is that the victims are not guaranteed everything. Because as I told you, when the Supreme Court, the highest court in the country, asks a rape accused, will you marry that girl? Mind you, it's a minor girl. Then how could a victim have confidence in the justice system? Because it is so unpredictable or inconsistent. True, victimology has been recognized and it has been attempted to be implemented into our criminal justice system. I think we have a very long way to go. Now, I won't stand in the way of the viewers and Professor Dr. Rose, who is a research pioneer and a renowned academician who would now elaborate on this topic. Now, over to you, Professor Dr. Rose.
Thank you, Prem, for putting things in perspective. And I'm sure that the stage is set for the grand entry of Dr. Rose Varghese. Ma'am, the stage is all yours.
Thank you, sir. Thank you. I think this series of lectures being organized by Advocate Shyam Padman with a dynamic team of judges who are so committed to the cause. I was almost missing Justice Ramkumar when I didn't see him at the beginning, and I was happy that he joined. And Justice Ramakrishnan also has all along been with the team, and it really inspires us to speak. But Mr. Prem Raj has already said whatever I wanted to say. really now I'm wondering what I should speak on, because he really covered what I wanted to see. I'm drinking water after hearing him because I don't know what to speak.
No misgivings.
Sir, see, when we speak of victimology or a victim-oriented criminal justice system, what pains me is cases, the old cases like Khatri's case, the Bhagalpur blinding case. A lot is spoken about victim compensation and women and victim compensation. A lot of steps being taken also, as Mr. Premraj has mentioned. But if we think of that old Bhagalpur blinding case, where people who were in the who were under trial, where acid was poured into the eyes of the under trials, and they literally became blind. It is in this context that I want to discuss the topic of victimology. Can it be compensated by giving them some money when they're perpetually now totally blind? What is the way in which you really can address the issue? This is what prompted me to talk on the topic. Though there's nothing new to what I'm going to say. See, crimes, as we all know, are still on the increase. Like we discussed at one of your sessions, sir, about death penalty, you try giving the worst of punishments. After 2013, Ramaiah case, if it's rape and murder, then it's death penalty. Is there any, are the crimes of rape followed by murder reduced after that amendment has come? So the truth of it is that crimes are on the increase, and it is evidenced by the fact that day in and day out, we continue to hear about innumerable crimes being reported. And Mr. Premraj mentioned in his talk, not all crimes are reported, especially when it involves women. They silently suffer, withdraw from it, and they refuse to file a complaint. Even the National Crime Bureau statistics would not be accurate, because not many would come forward to report a crime where there's already a traumatic experience and where our society continues to put a stigma to it. While teaching criminology and penology to my students, I used to ask the young boys in the class, it's a co-ed class always, to be very frank about it. I tell them, you can just be frank about it. If you know that a girl has been raped, how many of you would come forward to marry her? So I'm just trying to say that they know there's a stigma attached to it, so they don't often complain. But my point today is it's not just women victims. I'm talking also of elderly victims, the elderly. How many of us are really sensitized to the actual problems being faced by the elderly and the way they are vulnerable to crime? Especially in Kerala, I would say, many of the elderly have their children abroad. They live alone, and every day of their life, it's a threat. They check if the back door is locked, the front door is locked. They live under a threat, actually. Elderly victims, child victims, children below 12, or young children, timid children being abused. And of course, victims of sex offenses, a lot is seen and read about it and heard, and it continues again day in and day out. Then female victims. Well, there are other types of victims also when you talk of disparity in wages or maternity leave, or that air hostess case, what's Varghese Mirza, am I right? On an air hostess case where, okay, if you're pregnant, you've got to leave the job. Those are another set of victims. Then minority groups, weaker sections of the society, SC, STs, the way they're treated. I'm one who's totally, just as Ramkumar and just as Ramakrishnan, I don't know if you'll agree with me. I'm totally against casteism. I would call that also kind of they become victims of injustice. I don't know, somehow I can't accept casteism. And it prevails still. So when I'm talking of victimology, victims, I'm talking different types of victims. Now, the criminal justice system, we all know, and we have to admit it, we have to do that we focus on the accused, because, and then the victim becomes a forgotten entity, as Mr. Prem Raj Menon rightly said. We follow the accused. We try to see whether he's arrested and okay, brought before the magistrate within 24 hours, and then his rights once it's back in the prison. We all along until conviction, we follow the accused. We try to protect his rights also. The witnesses coming need the protection. So our focus is always on the accused, and there the victim becomes a forgotten entity. Now, what are the legislative and judicial responses to this issue? Besides the recommendations of various committees which have been set up to review the criminal justice system. When we look at the criminal justice administration, and when we are concerned with criminals, we look into their social background. The accused, I'm saying, I shouldn't use the word criminals. In criminology, we always remind our students to use the word accused. Until convicted, we call them only accused. Now, the causes of criminality, what is the punishment to be awarded to him? What do we do for crime prevention? All these issues come up. We all know we have an adversarial system as against the inquisitorial system. The accusatorial system, the crime has been proved beyond all reasonable doubt. So we can see that there's so much of desperateness on the part of the police personnel, the prosecution, the evidence, the medical evidence, for forensics, ballistic experts, all are brought in to try to bring home the guilt of the accused. And we know we have two eminent judges in our midst. An accused cannot be convicted. I'm so sorry. Let me put it on silent mode. I tell my students in the class that's the first thing they should do, but I forgot to. Silent. Now, what I'm trying to say is, even if an iota of doubt is in the mind of a judge about who exactly is accused, I'm sure the judge will acquit. Because the judge should not and will not take the risk of coming to a wrong decision. I'm not exaggerating, even an iota of doubt is enough for a judge to acquit. And that's why we see a lot of acquittals. And we are all in a blame game, you know. Is it the police investigation? Our investigatory machinery should be strengthened. Our prosecutorial system should be strengthened. Forensic science, we would say, no, that is not admissible. It's violating the doctrine of self-incrimination. So we are also, right from the moment the crime occurs, whatever be the nature of the crime, till the conviction, till the sentencing, even at the sentencing stage, the way he's treated in the prison, and then it goes on to sometimes then if it's death penalty, the pardoning power of the president, Article 72, all this, the entire criminal justice machinery is engrossed in this. Now, I'm not blaming the machine. We have to, which of these which I said can we dispense with? Is there any one step of what I said which we can dispense with? We cannot. But in the process, there's hardly any role envisaged for the victim. We will see that the victim would come and report a crime, and then she's told, she or he, don't take law into your own hands. The state machinery will take care. Now you can go, yes, okay, we've recorded your statement. And after that, it could be 10 or 15 years later that she would read in the newspapers that the accused is acquitted. Or if it's a murder case, prosecution failed to prove beyond all. Whatever. The victim there in the murder, the victim is the wife, the widow. What was her life all these 10 years? Actually, we don't get the time to concentrate on what's happening to her because we are so engrossed in our criminal justice system where we have told her, don't take law into your own hands. Don't ask your brothers to try to murder that guy. We will take care of it. Now, what is her role when I say, now we don't expect that she's asked to come daily to the court where the murder of her husband is being tried. But in the US, there is this victim impact statement. What is the impact the crime has on the victim? One of the courts I saw went into that and said, let's call for a victim statement. I'll come to that a little later. So we don't have any stage where the court is made abreast of the movements of the victim and the trauma that she's going through. Has she left school because of this incident? And is society still blaming her? Well, all kinds of issues. In state of Gujarat versus the Honorable High Court of Gujarat, the Supreme Court said, in our efforts to look after and protect the human rights of the convict, we cannot forget the victim or his or her family in the case of his death, or who is otherwise incapacitated to earn his livelihood because of the criminal act. And the court reiterates there that the victim is entitled to reparation, restitution, and safeguard of the rights. Is there any case where we really followed the victim? Criminal justice, the court says, would look hollow if justice is not done to the victim of crime. Now, in this connection, it's pertinent to note the observation of Honorable Justice P.V. Reddy when he said that we should take care, when we talk about criminal justice, there are 4 areas we should take care of in the interest of victims of crime. He says, furnishing information to the victim at the investigation and trial stage. How many would go back and inform the victim, now this is the stage in which we are, now it's like this, now this is going on, that's going on. Now it's Corona, so we are having virtual. Don't worry, it is still going on. There is virtual courts are happening. Then the second stage, he says, is facilitating the victim to take part. How many cases do we have where the victim is really seen in the picture, taking part? Now we would say, yes, she's represented by the state, but actually she's in the dark of what's happening. Even if she would call, she or he, I shouldn't just say she, if the victim would call the lawyer, the state lawyer, ask the public prosecutor what is happening. So you just sit back, don't worry, it's all happening. Then about monetary relief and compensation, there's a lot about it being said about it, how effective it is. We'll come to it a little later. Then Justice Reddy says the 4th thing, extend support services, providing legal aid, counseling, medical aid, and rehabilitation. When we talk of penology and of the accused, we always speak about the rehabilitative trend. We have to rehabilitate and reform him and bring him back to the mainstream. True, I agree with it, because I do teach criminology and penology. But how many of us are really concerned or aware of any of the big rehabilitative steps being taken for victims of crime? I Actually, the concept of victim, I'm not going into the history, it can be traced back to ancient cultures and civilizations when the ancient Hebrews spoke about the idea of sacrifice. Well, I won't go to all that now. Andrew Carman, K-A-R-M-A-N. He wrote a book on crime victims, An Introduction to Victimology. He says, rightly says, victimology is the scientific study of the physical, emotional, and financial harm people suffer because of illegal activities. Again, how many of us really go back to that issue of the physical harm? Okay, sometimes that is attended to. The emotional stress, the psychological stress, the financial harm he or she is undergoing. This one aspect we have to examine. Well, the scientific study of victimology, I would say, formally started in 1970, but I don't want to go to historical aspects. Let's see what the UN did. The UN Congress, 7th UN Congress on the Prevention of Crime and the Treatment of Offenders, 1985, adopted a declaration of basic principles of justice for victims of crime and abusers of power. It affirmed the necessity of adopting national and international norms to secure universal and effective recognition of and respect for the rights of victims and the abuse of power. It declared that offenders or third parties responsible for their behavior should make fair restitution to victims. This declaration is in fact described as a kind of Magna Carta of the rights of victims. This declaration speaks again of access to justice and fair treatment. 2, restitution, return the property or harm or loss suffered or whatever. Then compensation, then assistance, that part of it. To receive medical, that bill of, actually those rights of victim states, that the victim should receive medical, psychological, and social assistance through governmental, voluntary, and community-based means. Police, justice, health, and social service personnel should receive training in this regard. Do we give training to the police about how to handle a victim? I mean, how to train them, when the victim comes with the complaint. In fact, if we really, maybe in movies, they may exaggerate a lot, but still, they show how they ridicule the victim. Well, I won't go into details of it. With the issue of rights of victims of crimes, it emerged as a debate. Several states in the US actually came out with this big victims' bills of rights that spoke about the right to attend or participate in criminal proceedings. The victim could attend the trial. In fact, the victim could be present at the sentencing stage. We know that after the conviction, an accused under Section 235, Clause 2 of the CRPC is given a right to speak on the question of sentence. He is given another opportunity to speak, to be heard on the question of sentence. But this US Bill of Rights says the victim should also be present there. How often do we have the victim there? Now, do we allow the victim at that stage to make an oral or a written statement? So we don't have the victim impact statement, but at least for an oral statement. Well, victims are being given the right to attend in some places, but sometimes are they heard on hearings on bail, entry of plea agreements, post-trial relief, probation hearings? Where are they at that point of time? Well, I shouldn't again repeat. Now, there are certain kinds of protection to the victim. Police escorts to and from court. I don't know if we are really following it. Securing waiting areas separate for the accused. Separate from the accused. They are not put in the same room, during court proceedings. Then the witness stands that are shielded from the direct view of the offender. Then the right to confidentiality of records. The right to speedy trial, it's also for the victim. It's not only we speak of speedy trial about the accused, but even for the victim. Then the right to prompt return of the victim's personal property which has been seized. Then victim compensation and restitution. In France, and where there is an inquisitorial system of criminal justice, the victims are entitled to be parties to the proceedings from the stage of investigation. It starts from the stage of investigation and right through till the conviction. In the light of a clear distinction between torts and crimes, compensation appears to be a civil remedy, and punishment apparently is related to criminal law. I agree, the remedy in torts is more compensatory in nature, whereas the remedy in crimes, it is punitive in nature. We want, we want to see the accused behind the bar, not this bar. Oh, he would be so happy if he was put there. But we want him behind the bar to be incapacitated because he's a threat to society. Now, in the process of the evolution of the criminal justice administration, the concept of victim compensation has a major place now, even in the Indian legal system. Let's quickly peep at our legislative philosophy, policy. I won't go into it. I have honorable judges and leading senior lawyers sitting here. But you all know Section 357 of the CRPC. But it's amazing that in India, the concept of compensation is not new. It existed even in the ancient legal system. Manusmriti speaks of that the king should impose a fine in direct proportion to the amount of pain caused. So we all spoke about it. It's not a new phenomenon. But then what is the provision we have in India? We have, of course, the CRPC and the Probation of Offenders Act, which speaks about, touches on this topic. CRPC, of course, as I said, the judges here, I should not be even mentioning it. But we need to note that Section 357, Clause 1 is applicable where fine forms part of the sentence. Of course, this is known to our lordships and others here, but I'm coming to one aspect. Just a second. I'm going to one aspect. Section 357(1), where fine forms part of the sentence. I've always, I think even at the last meeting, I told Advocate Shyam, Padman, we need to help whoever is in the process of looking at reforms into the IPC, which was drafted in 1860. We know what is the fine stipulated, because it was drafted in 1860, and the fines mentioned are 500 rupees or 100 rupees, or even sometimes some paise, I think. But Section 357(3) can be utilized where the court can direct the convicted person to pay compensation, even where fine does not form part of the sentence. But how many of the judgments, how many of the courts are really utilizing it effectively? Pay compensation of 5,000 rupees. I'm again remembering Khatri, and I'm remembering other Nirbhaya type of cases where the intensity, the horrendous crime which is reported can never be compensated. But okay, utilizing the provision, some fine the court can direct. It's always in thousands. Now, there is this, the High Court actually can exercise its inherent power to pass appropriate orders to secure the ends of justice under section 482. I don't know if that is also being utilized effectively. It can include an order to pay compensation. Now, we also have section 421, which provides for means to recover the fine by attachment and all that. We have section 431, which empowers the courts to recover any money payable by virtue of any order. We also have the Probation of Offenders Act, where the court authorized the court, the act authorized the court to directing to release the offender on payment and on an order to pay compensation as the court thinks reasonable. So it's not that we don't have any provision. It's not that the legal fraternity has not at all looked into the issue of compensation, but how effective is it? The Law Commission in its 42nd report, and again subsequently I've noted another report of the Law Commission, 277th report, where they have also spoken about, the Law Commission in its 42nd report, in fact, noted that the courts have not been utilizing these provisions effectively to award compensation to the victims. Now, the National Commission to review the working of the Constitution, that was in 2002, if I'm not mistaken. This National Commission was there to review the working of the Constitution. But you will note, while reviewing, the review committee observed that the victim under the criminal justice administration remained a neglected one. As Mr. Prem Raj reminded us at the outset, a forgotten entity. The commissioner opined that the assumption that by punishing the offender, the victim receives justice is doubtful today due to the decreasing number of successful investigations and convictions. So that's another aspect of the problem. Now, given the inconvenience, delays, corruption, and harassment, many victims tend to keep away from reporting crimes. And in fact, that leads to a tendency to take law into one's own hands. So if we are not effective, it would lead to, the victim's brother, beating up the accused and things like that. Well, the commission was of the view that among the many reforms advocated for criminal justice was a victim orientation to criminal justice administration. Well, there they said victim orientation included, I'm talking of the National Commission to review the work of the commission, review the work of the Constitution. They said victim orientation included great respect and consideration towards victims and their rights in the investigative and prosecution process, provisions for greater choices to victims in trial, and a scheme of repatriation and compensation, particularly for victims of violent crime. So repeatedly, many bodies have suggested this, but how effective is it? Now, the committee felt that a case for a viable social justice-oriented and effective scheme for compensation was widely desired. And the government at the union level and the states were well advised under the directive principles. They are advised under directive principles, as well as under the international human rights law obligations to legislate on the subject of an effective scheme of compensation for victims of crime without any delay. How effective is the scheme and what schemes do we have? In 2005, a bill was introduced to amend the CRPC to set up a criminal offences claims tribunal. Chapter 3A of the Act CRPC Bill 2005 introduced was with the objective of protecting the rights of victims in crimes against them by providing compensation. Now, by this, we got some respite because by the Code of Criminal Procedure Amendment Act 2008, Section 357A was incorporated, which spoke about victim compensation scheme. We all know now we have Section 357A, the victim compensation scheme, that every state government in coordination with the central government shall prepare a scheme. District Collector Alleppey versus District Legal Service Authority Alleppey in Section 357A, 1, 4, and 5 CRPC, which are substantive in character. In that case, it was reiterated that they are entitled to claim compensation for incidents that occurred even prior to the coming into the force of this act. So that's something which I noted. And in this case, the Kerala High Court has held that the provisions in Section 357A are substantive in character, and the victims are entitled to claim compensation for incidents even prior to the coming into the force of the said provision. So, leave alone prior to the provision, when after the coming into effect of this act, how effective it is. I think Justice Betchu Kurian Thomas very recently, in this case, posed a pertinent question. The question relates to the victim compensation scheme under Section 357A of CRPC and its applicability. He raised the question, is the provision retrospective or prospective? Now, I'm going to a step further. Let's assume it's only prospective. Even if it's prospective, how effective it is. Now, that's about 357A. Now, Section 372 CRPC. In the interest of victims, there's a proviso to Section 372 that it provides a right of appeal to the victim against any order of acquittal, conviction for a lesser offense, and imposing inadequate compensation. Really, I'm so happy we have judges here who would share with us also whether there have been instances where the victim has come forward with saying about that the sentence, the compensation was inadequate. Well, that should come from the prosecution side. But how many cases? Actually, the truth of it is they remain silent. Now, the Indian judiciary, I don't have to tell, Mr. Premraj Menon mentioned all the cases which I was planning to speak of. So I'm not really going into it, but we all know that a breakthrough in the field of victimology in Rudolf Shah, where the Supreme Court asked the state of Bihar to pay a sum of 30,000 rupees, in addition to a sum of 5,000, which is already paid. Now, the observation of the Committee on Reforms of Criminal Justice System was that people have lost confidence in the criminal justice system. And the point there was because of the compensation scheme. When I was talking about crimes against women in another session with Advocate Shyam Padman, I referred to Kunyimon versus State of Kerala. I was telling you all how it's not that this is a very new phenomena or that just recently people are talking about or thinking about the victim. Because Justice Chetu Shankaranaya in that case, I'm quoting him. An offense of this nature, it was a rape case, must receive a deterrent sentence. Any rational system of sentencing involves a correspondence between the nature of the offense and the nature of the sentence imposed. And he goes on to say that rape is an offense involving extreme moral turpitude, at once displaying callous disregard for the dignity of the individual. And then he says, there can be no compensation for what she has suffered or lost. The intangibles are incommensurable and cannot be translated into monetary terms. So then, even when we talk of compensation, we know it cannot be brought down to monetary terms. But even then, even there, what is the compensation being awarded? How effective is the provision? Well, there are a whole range of cases. I'm sure I wouldn't want to take you to all of that. Hari Singh, in Hari Singh versus Sukhbir Singh, the courts highlighted the importance of utilizing Section 357, Clause 3, more than one. And the judge noted that it's hardly being invoked. And it empowers the court to award compensation while passing judgment. In Kamlagar versus State of Maharashtra, we can see the court in a case of 498A cruelty case, cruelty by the husband or relatives. The court has asked the accused to pay 5,000 rupees to the victim. You may ask me, is it an old case? It was a 2004 case, but the fine awarded was 5,000 rupees. In Jacob George versus State of Kerala, the High Court awarded a sentence of 4 years and a fine of 5,000. I'm not talking so much about the quantum, but the heights of inadequacy of compensation. I would say today, even if the victim was paid in lakhs, we are saying it's inadequate and it is not really, it cannot be measured. But this is the majority of the cases I went through, the compensation is it's just 4 numbers, 4,000, 5,000. See, the Supreme Court in state of Andhra Pradesh versus Kunna Satyanarayana was a very, very good, one of the well-written judgments of our court. But still, when it comes to compensation, say the judge remarked under, it was only a special leave petition, but the judge said, I cannot find any justification for the High Court's order on the reduction of sentence. The reduction to 2 months, even in the imprisonment, the judge said seems like a mockery of the law. But then it goes on to say that the ends of justice in that case was met by imposing on the respondent a sentence of 3 years with a fine of 5,000 rupees. Well, we all know, we talk of giving compensation as if a victim is waiting for the money. But we know there are cases like KPS Gill, where she was given 2 lakhs. And she said, I don't know, she refused to accept the monetary compensation given to her. And she said, it can be given to any women's organization engaged in doing service for the cause of women. So there are victims who also, they don't want to accept the money from that person. A tribal woman was in police custody. A man was in police custody in the matter pertaining to a rape of a tribal woman. And then the court ordered a sum of 50,000 to be paid as interim compensation. I'm only trying to tell you that there are cases also where the compensation is even more. Commenting on the heinous crime of rape, the courts in Subra Chakrabarti's case says, rape is not only a crime against the person of a woman, it's a crime against the society, and it destroys the entire psychology of a woman. I picked up this case just to tell you, psychologically, she's shattered. What do we do for that part of reparation? It destroys the psychology of a woman and pushes her into deep emotional stress. Is that part of her problem taken care of? Now, the National Legal Services Authority was asked, the Honorable Supreme Court in Nipun Saxena's case, Nipun Saxena versus Union of India, the Honorable Supreme Court opined that it would be appropriate if NALSA sets up a committee of about 4 or 5 persons who can prepare model rules for victim compensation for sexual offenses. And a committee was set up, and they have come out, of course, with this compensation scheme for women. You'll be surprised to know that with this central victim compensation scheme, a huge amount has also been set up for that. But there's no awareness. Victims are not even aware that there is such a victim compensation scheme. Because after the Nirbhaya case, the government sets up the CVCF, Central Victim Compensation Fund. And the initial corpus was 1,000 crore. There were widespread reports of, subsequent to that also, the non-utilization of the fund. It's not being utilized because of lack of awareness, and even where there's awareness, people don't really see the need to focus on that part of our criminal justice system administration, because we are so much engrossed in what to do with this accused person. Of course, we cannot neglect that part of it. The accused cannot be let scot-free. So it's just the lack of awareness of the scheme, which is a major problem. Now, there are other provisions, section 358, compensation to persons groundlessly arrested, 359, order to pay costs in non-municipal offenses. Let me go back for a moment to the central victim compensation scheme. Uniform compensation was determined for all states. 3 lakhs for acid attack and rape victims, 1 lakh for rehabilitation for victims of human trafficking and other offense. Cases where the victim was below 14 years, the compensation had to be increased by 50%. Now, even this, which has been set, even by figures are set, how many cases, how many victims have really been, we're not talking of a minuscule percentage, but how many have really been getting this compensation? Another thing is, we know about compensation of victims from Motor Vehicles Act. A lot of that is taken care of actually by the insurance policy. But for other victims whom I named at the outset, about elderly, the child victims, SC, ST, the minority, other minority groups, the weaker sections, what is the attention being given, and what ought to be? When we teach our students jurisprudence, we always say that the positivists are focusing on what is the law. Whereas in our old jurisprudence classes, we all know Austin, Kelson, Hart, all of them focused on what is the law. Whereas the natural law theorists, St. Thomas Aquinas and others, went on to say that there's no law if it does not meet the principles of justice, reasonableness, and one more, no? Justice, morality, and reasonableness. It has to pass these tests. So we have lots of provisions, victim compensation schemes, laws, but does injustice still prevail when we look at law from a victim's point of view, from a victim's perspective, not forgetting that the victim is totally in dark of what's happening. And it's many years later that the victim gets to know about the acquittal of the accused, as the prosecution has failed to prove beyond all reasonable doubt. So I'm still troubled about the criminal justice system, where we need to focus on victims from a victim's perspective. I don't know how many minutes I spoke. I have a lot more of cases talking of compensation, but I like some discussion also. How long did I speak, sir?
Just 5 minutes.
It's, I can say, sufficient enough to cover the topic, but keeping us, asking for more, I'd say.
You know, sir, what I want to highlight is that if there is a victim compensation scheme, but it's not, people are not aware of it, or even if where people are aware, it's just a mechanical process which is happening. The courts, I would say, the courts are day in and day out awarding compensation, asking of paying of compensation. I don't know if I mentioned the case of Ankush Shivaji was state of Maharashtra. Yeah, I did know at the outset. Now, the interesting thing is that the courts are very much sensitized to the issue. But when it fails at the implementation level, it's a blame game. Whom do we blame? Who takes care of the situation? How effectively could we bring about a criminal justice system focusing on, from the time of reporting of crime, where do we give attention to the victim until he or she is, I wouldn't use the word satisfied, because they could never be, there's no question of giving, compensating, and we cannot measure it, the loss that they have suffered. But how could we make this more effective? It's not that we need to have more provisions, because we have provisions in the CRPC. And it's not that when it's especially 357 clause 3 is vested with the judge, there's no figure quoted. They could go to any amount depending on the proportionality principle, as Bentham says, you know. Looking at what stage would it really give justice to a victim? We all speak about the Indian Constitution and the preamble and notions of such noble values. I tell my students of constitutional law, such noble values, but to what extent do victims of crime enjoy these values of justice, equality, fraternity? So, well, I would like you all to discuss so that I could speak more. Because, yeah, let me tell you, in Ankush Shivaji's case, I was saying that the Delhi's, that victim impact report was, I was telling you in the US there is the victim impact statement, but in the Ankush Shivaji's case, the Delhi court asked for a victim impact report to be filed by the Delhi Legal Service Authority. And in every case, the Delhi Legal Service Authority is asked to file a victim impact report for every case. Well, it would help the court to know, is the victim blind or bedridden after the incident? Has the victim had to give up education? Is the victim in a mental hospital? So that is happening because the Delhi State Legal Service Authority has been actually asked by the court in this case to come up with this victim state impact report. Whereas in USA, in every case, a victim impact statement is submitted to the court, which would help the court in measuring the extent to which she needs to be, whether it's not, sometimes it's not compensation. It's not money that the person requires, but some kind of rehabilitation. Do we have enough of rehabilitation centers for victims of crime? Do we have enough counselors set up just to counsel a victim, a young girl who has been traumatized? Like Justice Chetur Shankaranaya in that case says, she has lost the prospects of a serene life. She has forever lost the prospects of a serene family life. That's now, for her, that's out of question now, because she has already reached that, our euthanasia case, Bombay case, Shanbag case. What was her situation after the rape of the male staff raped her? How many years did she languish in jail? Is there any kind of reparation which can be given to the family members? She was in a vegetative state, and then the issue came, should we make euthanasia legalized? Should we legalize euthanasia? There are so many victims today who are in that kind of a vegetative condition today. So that's why I say, shall we turn our attention towards what best could be done for a victim of this kind? In the euthanasia case, of course, we came up with Passive Euthanasia Act. I'm not going to that aspect. Even the attempt to suicide, I would like to bring in here, our section 309 of the IPC. If a person, a woman who's raped, she can't face society, she just decides to end her life. If she's successful, okay. But if she's not, she's herself in jail for attempting suicide. But yet I'm not arguing that for attempting suicide, you should allow them to and not convict. I'm not arguing for that. I myself feel we should not encourage that. Because if a child fails in the 10th standard or 12th standard, the first thing they do, they try to run and commit suicide as if it's the end of the world. They are also victims. Because when they attempt suicide, they are just put in jail, but actually, how much of counseling is happening? Do we have a systematic way of handling victims? Just as the CRPC gives us so many provisions of rights of the accused, what to do with the magistrate's power, everything is given. Like that, do we have an enactment? For everything, maybe an act is not possible, but a set of norms of how to handle a victim of any kind of offense.
Thank you very much, Rose Madam. And before I go to Justice Ramkumar sir, the topic itself cannot be said to be black and white. It has got different shades of gray in the sense like, sir, it was mentioned that accused is heard before the sentence is passed. And in certain jurisdictions, even the victim is also heard. Sir, my doubt was that before, when I request you to offer your comments, may I just also ask one thing, whether the victim was properly rehabilitated or she or he is further traumatized or completely shattered? Will that weigh in the mind of the judge while pronouncing the sentence, which is circumscribed by the specific provisions of that criminal statute? Sir, over to you.
Yes, it is a very timely, meaningful articulation on a subject of great contemporary relevance. There's a welcome reversal of the mindset of the stakeholders, and we have started realizing that in the forensic battles between the state and the accused, the victim is not a stranger anymore, and not to be marginalized or forgotten. There were indeed occasions when the bar and the bench were oblivious of the existence of the victim, living and dead, and primacy was given to the rights of the accused. This is more so when the victim is a juristic person like a state government. The classic example is A.R. Andule versus R.S. Naik. If we closely examine the progression of that case, very disappointing. In fact, I have promised a series of lectures with live law on that particular case. There were about 10 cases between R.S. Naik and A.R. Andule. Ultimately, what justice was done, it is really disappointing. I have in our rank, but one thing is, as you rightly said, Mrs. Rose Varghese, that we always advise the victim not to take the law into his hands. Why? Because there is the state espousing his or her cause. But is the state espousing all her grievances through the public prosecutor? Then is the victim's, then section 273, you rightly said, under section 235(2), while the views of the accused on the proposed sentence are being ascertained, the views of the victims are never taken. There's no provision also. Similarly, under section 273 CRPC, there's a right given to the accused that evidence shall be recorded only in his presence. Is there a corresponding right given to the victim that the evidence will be recorded in her or his presence? No such right given. Even under section 357, of course, awarding compensation, even under section 357, the interpretation has been in favor of the accused. In one case, Supreme Court said the means of the accused to pay the compensation also should be taken note of. Supposing, and he is a penniless person, and the crime committed by him is very horrendous. If you go by his means to pay the compensation, the victim will go uncompensated. Probably that may be a situation where the compensation scheme, the state's compensation scheme should be pressed into service. And one aspect to be noted is in the 357 compensation, the case need not end in conviction. Even at the stage of investigation, court can award compensation. In fact, that is a very salubrious, very welcome provision. Then, even while giving certain rights to the victim, the legislature was not conscious enough to give the corresponding right of appeal to the accused. For example, while discussing the criminal appeal, I had occasion to articulate on that aspect. See, supposing the trial magistrate is, supposing it's an offence punishable under section 326 IP, magistrate acquits the accused. Victim can go up in appeal. Victim can go up in appeal to the sessions court. Supposing the session court in appeal convicts the accused, there is no right provided for the accused against conviction, because the provision says in a conviction, the accused who has been convicted on a trial. Now here the trial was conducted by the appellate judge, not by the trial court. So no provision for appeal actually given under section 374 CRPC. Likewise, there has been some failures in even though while recognizing the rights of victims, there have been certain no corresponding provisions have been made by the legislature. Then our anxiety must not be to give too much importance to the victim. Let us not forget that.
Yeah, we cannot overemphasize. Yes,
exactly. Let us not forget that the so-called victims are not really true victims in all cases. There are fake victims set up either by the police or by the complainants, and they also should be identified. Courts should be capable of identifying such persons also. Remarkable articulation. Good, thank you.
Your Lordship, that since Mr. Premraj had mentioned, I didn't go to again mention the same case, that Chairman Railway Board was Chandrima Das. That's one of the few rare cases where the state was asked to pay 10 lakhs compensation because that person happened to be they were railway employees. So that way the state, when the accused is, because the state administration is setting in, saying that you don't take law into your own hands, we will take care. And then the state also has some responsibility, because we are all looking at how to deal with crime after a crime is committed. But prevention of crime is something the state has to take up that responsibility. How much of steps are being taken to prevent crime and not wait for a crime to occur? So when it occurs, the state also has a responsibility. And in this kind of compensation, like Rudal Shah and Chandrima Das's case, if that kind of responsibility is given for the state to pay compensation, they would also have some deterrent effect. I think so.
You're right. A crime-free a crime-free state is our dream under Article 21 of the Constitution, but it is only a distant dream.
I said, Justice Janaki Amma the other day, I was mentioning, I think, how Justice Janaki Amma said that no country can claim to be cultured unless a woman could walk out at midnight bedecked of ornaments without being robbed or molested.
Correct.
No state can claim to be that.
That is the litmus test which can be applied.
But the Malimat Committee report also, actually, Committee on Justice to Victims of Crime, actually, they really emphasized on victim participation, in criminal proceedings. But your lordship is right. There's a limit to it. We cannot overemphasize it.
All victims are not real victims, true victims. There are fake victims also because of the false implication cases.
That, of course, your lordship. But we are talking of people who really are victims, really victims.
How do we decide that?
Genuine victims.
Because the court is not witnessing the crime. The court acts only through the witnesses, who are the ears and eyes of the court. But when the witnesses are not honest enough to depose before court, justice will be the first casualty.
But if in a murder, if the husband is murdered, the wife, if he was the only breadwinner in the family and there are 5 children to be brought up, and they are sort of asked to get lost. If they go to the court says not the court, sorry, the police, they would be told, get lost, we are taking care of everything. You will be told at the end what happens. After 15 years, if there's a conviction, that's what I was trying to emphasize.
I am yet to come across a case, a closure report filed by the police in a case where they are really convinced that the so-called offense committed was in an act in exercise of the right of private will, which is not an offense. If it was done within the 4 corners of law, the right of private defense, it is not an offense. Even when the police are convinced that it was in proper exercise of the right of private defense, I am yet to come across a closure report. They will only charge for murder.
The comments of Ramesh sir.
It's a thought-provoking lecture given by Mrs. Rose Varghese on this aspect. But the question is not that. Question is, when you come to the criminal justice delivery system, you are only deciding whether a particular person has committed the crime or not on the basis of the evidence, and convicting and also providing sentencing policy is also utilized on the basis of the provisions provided. If you go by section 357(1), the fine is there, you can only award compensation out of the fine. In most of the cases where magistrate courts are deciding the cases, only in heinous cases, a limit of fine is not provided. Where the only says the imprisonment and fine, etc. And only in such cases, you can imagine the question of awarding a huge amount as a fine and then direct them to pay adequate compensation out of that. In all other cases, the law itself provides for, and another thing, 357(3) cannot be straight away used when the imprisonment and fine is provided, because you will have to exercise both. You cannot say that I am not imposing fine, I will go for compensation, I will use my discretion and pay.
And sentencing limit of the magistrate also is 10,000 only fine.
No, that is the reason why I said wherever the provisions are provided, the powers of the judicial officers, the courts were also mentioned there itself. So certain courts where even if they feel that they will have to pay more, they may not be able to pay it, or unless it is provided imprisonment with fine or without fine. Only in cases where without fine is there, they can exercise the jurisdiction there also, unless the provision is there in the act itself to pay compensation. Otherwise, they may not be able to do that. So that is the reason why in 138 it was mentioned that if you invoke section the fine, out of fine you will have to pay double the amount of fine, and the case doesn't say that check amount. though the act says. Subsequently, it was amended and then the power was given to the magistrate to provide that aspect. So when the act was envisaged, there was not envisaged by the legislature that magistrate power must be increased for that purpose. So that is how that come only because of the judicial decision. And thereafter, the amendment came. Section 29 of the CRPC was amended and special provision was provided in the NI Act itself for providing it. And another aspect is now the nature of crimes are also going up. See, for example, the honor killing. Cyber you forget about. That is a technological crime.
Crime.
I am talking about the sociological crime like
Honor killing.
Honor killing. How to prevent it? Because when you say, when one side the law says you have got a right to choose your partner, and when the partner being chosen by the parties and the parents were not happy with that the partnership, then again the victim is none other than their own child. But that fact is being forgotten by the people. So though we say that we want a casteless society, we want a secular society, etc., etc. I do not know how far we have forwarded to that extent, in spite of the fact that we have passed nearly 70 years of independence.
Really?
See the matrimonial columns.
So these are all the areas where, as you have rightly said, the prevention is better than cure. Before committing the crime, you will have to analyze the sociological background and also the persons who are rightly involving such crimes or repeating such crimes. And what is the necessary, what makes them to do it? What is the criminal background or the psychological background is that boy or girl is put under. And that root cause is being found out, and then that person is being treated. Because society itself will have to be treated, I can say. The counsel is required for generally for these purposes. Again, rightly you have said, the victim is being in fact, I can say they are being further dramatized on account of this. Stigmatized also. So what is the nature of respect that is being given to the victim? He goes to the police station or to the court when evidence is being given. Whether the protection or the respect that is required is being provided to them or not. These are all the areas where one. Secondly, immediately after the commission of the offence is informed to the police, the first thing is they are going on for interrogation of the victim. They are not thinking about the mental status of the victim as to whether she is able to give evidence or she is able to give answers to the nature of question that is put to him for the purpose of bringing the what you call the ingredients of the offence. Because unless the ingredients of offence comes, there is no charge sheet is being provided. So these are all the areas where you will have to find out method by which how the sociological background of the victim will also have to be gone into by these people for the purpose of before exercising the right of questioning, etc. And after questioning also, if they feel that certain remedial measures will have to be provided, as you said, the retribution or retrieval, what you call putting them back to the original position, however is possible, and what is the nature of the what you call counseling or retributive system will have to be provided for the purpose of bringing them back to the society, to forget about the stigmatization and bring them to the front line of the society itself. So such a type of the activities are not coming up from the investigation. I can say only that must come from the investigating agency. It's the police. There must be a separate wing in the police system itself for the purpose of investigation and also providing counseling and put them in the right path as how this can be compensated and how they can be put in right. And forget about this traumatized act that she has undergone. And also to come to the real life, forgetting about all those aspects. It's very difficult. We can easily say that you can forget all those things, forgive those people and go forward with your life. But how far it is practicable is one aspect that we'll have to think about. The psychological aspect of the victim also will have to be gone into all those aspects. So again, another thing also in the legal system. See, once a crime is committed, whatever be the nature of crime, after recording the FIR and also recording 161 or 164 statement, we forget about the victim. Only in cases where the cases are referred, notice is being given to that too not to the victim, only to the informant. Because informant may not be sometimes a victim also. So the victim may not be knowing about the outcome of the result of the investigation as well, unless there is a provision provided in the CRPC to inform the nature of charge sheet that has been provided, so that she may be getting an opportunity of challenging that or filing a private complaint to add more grievous offenses if it is necessarily there are evidence that has not been taken care of. So these are all the areas where I think that some more legislative intention has to come forward for the purpose of enactments will not be made to improve the system for the purpose of providing actual justice to the victim of the crime. Because victim includes, as you said, accused also, because when the Human Right Principle came, they are also concentrating on the accused.
Rights of the accused. Yeah.
Rights of the accused. What is the custodial in the harassment that is undergone? Torture, or during the investigation, during the period of investigation, what is the nature of torture that is being undergone by them? They never thought about how the victim is being questioned, how the victim is being handled by the prosecution agency for the purpose of getting the evidence, etc. Also, the participation role, as far as India is concerned, I do not know how far it is practicable, because at all times when you are not getting evidence, again you will have to go to the victim and ask for further nature of material to trace out the persons who are responsible for the offense. Because the victim is an helpless person, may not be sometimes able to provide all the necessary thing, maybe due to fear or maybe due to other stigmatization, police coming to their houses for often for the purpose of getting these particulars, and the society looking at them that every time police is coming to you and they are reminding of the past history. So those are all the areas where we'll have to think about how this can be what you call in a harmonious manner it can be done. As rightly pointed about by you, the 482 can be possible only if the law provides. Suppose the section, as I said, the section itself combines with the sentence. Court cannot go beyond that, because Article 226 and the Article 32, court can invoke the extraordinary precatory power and then impose compensation, whatever manner, directly, even without collecting evidence or trial being conducted as to what is the nature of amount to be paid, etc. That can be possible, but that is not feasible. And when you comes for a trial system and adversarial system, that the courts are limited with the powers provided under the statute itself as to how the punishment will have to be provided. So that is one handicap that the trial courts as well as the appellate court, when dealing with the criminal justice delivery system, is being handled. In order to avoid that, only the 357A victim compensation scheme, etc. has been, as you have rightly said, if I remember correct, that the National Legal Service Authority entrusted the task of conducting the investigation to assess the compensation to the state legal service authorities.
Yes.
I do not know how far the state legal service authorities are exercising that powers.
Exactly.
Are doing it. So that is the area where the law, as far as India is concerned, it is not like other countries. Law is there. Enforcement agencies and implementing agencies are lacking behind. So these are all the areas where the state has to take a role and find out methodology by which it can be liberalized and reach streamlined and reach the victim as a real victim, the expected compensation or expected relief. And I do not know, though there is a provision for providing employment for such victims, how many of them were employed, I do not know. All those
that was a very good option, actually.
So that's a very good option, because
where possible,
depending upon the qualification, etc., you can absorb in some areas where you can provide it, just like the compassionate employment given to the employee who is dying harness. Just like that, you can provide some provision for that purpose, or some percentage can be provided for that purpose. So that is this.
Your Lordships, even for the accused, I'm wondering whether, incarceration, long incarceration in jail, from morning tea, a cup of tea for 1,000 of them. I took my students to Tihar jail. Thousands, they have to be provided, starting with morning tea, nasta, breakfast, lunch.
No, you are streamlining that. You are also
great
monitoring it by a district judge, a session judge. Visit the trial, and
yes,
find out whether
I take my students to the jail. Your Lordships, I'm thinking, imagine
he will also
the
have
cost.
tea. He will also have tea.
And we are expected to drink the tree and the food that has been provided to them to find out whether it is being properly served to them or not.
No, but imagine the cost to the exchequer. Instead, was it not better to have like this order to community service? Community service orders were more effective. Instead of locking them up in jail, if they were asked to go and wash the railway platforms and the bus stands and the toilets there, that has more deterrent effect. Similarly, coming to our point, more than incarceration, I'm wondering whether making them pay a huge amount of money is more deterrent, because the people, people have a love for money more than anything.
Madam, another question is that, as I can rightly said by the Supreme Court, merely because suppose, no, not that. Suppose a penniless person,
that's
you are ordering crores of rupees as compensation.
That I agree.
It will be only the paper.
No, that I agree.
So, unless you have got a property to recover, it will not be possible. So that may be the reason why the National Legal Service Authority come with a scheme of having a fund to be provided for that purpose, and 357A was added. So that must be properly streamlined, and also there must be some mechanism to supervise as to whether that is being properly implemented. If not, where is the gap arises and how the gap can be rectified. That is the area where the state government has to take a role.
For socio-economic offences, a punishment by way of monetary thing would have a better deterrence than putting them in jail.
I think these are all the areas where social welfare department of the ministry has to take care of all those things, and that must come under them for the purpose of implementation, apart from giving it to the home department. Home department is only concerned with the investigation and law and order and other people. But social welfare department must be given. They must be linked with the legal service authority to find out what is the nature of cases pending of such nature, and what is the nature of investigation mechanism that can be introduced for the purpose of finding out, as Justice Ramkumar has said, real or fabricated cases. All those things real or fabricated can be come into play only when after the evidence is over. Even after the evidence also, if all the witnesses come and say in a particular manner, without shattered on the basis of the cross-examination, ultimate is conviction.
And perjured evidence.
We do not know. The court has got only limited, unless your sixth sense or divine sense, what you call it, comes to a conclusion that there is something fishy. You will have to find out some method by which you will have to disbelieve the witness and give an acquittal to that. And then it is then such acquittals will be being criticized by the media. So that also there, when all witnesses goes to the witness box and say support the prosecution, ultimately courts ended in the acquittal. What is the nature of justice is being given to the victim? That also will be there, because the persons who are not going into the question whether it is a real case or not, they are only sensitizing the issue. A woman has been, or a victim has been victimized. Whether they are not going into the cause, they are not going into the reason, whether the what you call the truthfulness. That is the reason Justice Malimat Committee wanted finding out the truth must be the basic principle to be adopted in a criminal justice delivery system. But that was not accepted by the.
He spoke about the quest for truth.
Quest for truth. But that was not accepted to the parliament.
It was not accepted. And he also suggested borrowing a few
provisions of the CPC, also finding out, giving the written submissions by written statement by the accused regarding the offense.
Right to silence.
Right to silence has to be broken. And you will have to say.
The Malimat Committee report also spoke about borrowing some of the features of the inquisitorial system in France, where the judge plays a more proactive role. Because of this accusatorial system ending up with lots of acquittals, where the prosecution has to just prove beyond all doubt, which is never possible, and therefore a lot of acquittals are happening.
Not only that, if you go by the foreign system, I don't think that they won't deny the incident. They admit it.
Basic honesty.
If it is ultimately found he is giving falsity or false statement, he will be stigmatized as a person uncreditworthy. So the people are afraid of that. Stigma is coming to his reputation. But here the question is not that they will only try to defend the act within the four corners of the exceptions provided under the provisions. So that is not then the prosecution, the role of the prosecution or the task of the prosecution is very limited.
Limited then.
And the court's duty also very limited, because you will have to find out whether he can be fit in the exception provided or not provided. Because offense is admitted, commission of the act is admitted. The question is whether that will come in under the four corners of the offense provided under the statute is only question to be considered by the court. So these are all the areas where we will have to go a long way. And our society must also raise to that occasion and find out methodology by which, because all these things can't be possible only if the people have faith in the investigation system also.
The investigation
system also will have to, because we find
has
from
to
a
be-
lot of cases where the planting of witnesses, collection of false evidences, fitting in certain things where there are loopholes where it will be fit where the witnesses were not able to answer. All those things are areas gives a room for suspicion about the truthfulness of the investigation that is being conducted also. So that is the reason why right to silence, as far as India is concerned, innocence is the rule, conviction is the exception.
Exception.
So
And,
it's an area where it is a lot of things will not be looked into by the people, and also persons like the persons who are fighting for the right of the victims, I can say. Because merely because saying that investigation, arrest, etc., you will have to find out the method by which, what is the reason for the society going for so much crime bound. And also the things which we are not expected of during olden days, our school days. Now we are not able to think about, even you and I will not send our children with in that way. That is the reason why we find that the character of the people, the morality value-based the education is not there. So all those things will have to go back to some extent. Even now we are questioning whether this Manu was existed or not. There are some articles now coming saying that it is Manu Smriti, etc., or is only a myth. How can you say Manu existed at all? Though in the law college students, we say that the Smriti and Smriti is one of the sources of law at that time, which gives the basic for how the justice system is done in those areas, those days. So these are all the areas where we will have to think about. And it is for the state government to take into confidence of a lot of stakeholders who are dealing with this. I can say the NGOs, all those people who have to sit together and find out how this can be properly monitored, and the benefit of the scheme goes to the right person. That is, I will underline the word the right person.
Correct.
So that also will have to be there. Thank you very much, madam, for a thought-provoking subject that has been taken up of a contemporary period that has, just as Ramkumar has said, because the crimes are increasing.
We have noticed that our main bane is dishonesty at every level. Investigation, prosecution, even in judicial.
Integrity and professional ethics. I tell my students at the time of orientation, when they come in the first year, I tell them now with all these laptops and all their facilities, they can access any mode of, technological thing to get knowledge. You can acquire knowledge through the years, I tell them, but your moral values, integrity, you better imbibe it right now if you don't have it.
Unless you practice reading,
professional ethics is so important.
Really true. We have Virupaksha Gowda sir with us. Sir, your comments on that. You are also a very a stakeholder in this discussion, because you have been seen both sides of the bar and the bench, of course. Sure.
Yes, sir. It was an excellent presentation, sir. When we hear a professor, it is usually more of an academic exercise. But here we have Professor Varghese with practical aspects, just as a lawyer would do. I have just one more aspect which needs the attention of this assembly. In the matter of withdrawal of prosecution, the victim is not given any role or locus standi. Several times, without even any notice to the victim, cases are being withdrawn by the government by filing petitions under Section 321. Probably we need to ensure that victim has a locus standi in such matters. Thank you.
Very important aspect, sir. Very important, sir. It's true. The victim doesn't even get to know that it has been withdrawn.
Shyam? Yes, Prem, I think Shyam is out of.
All those functions are taken over by the state. That is the problem.
Yes,
Even
sir.
withdrawal is
Yes.
taken over by the state.
Yes, sir.
And we all anticipate, we all are under the impression that state will act fairly, honestly, sincerely. But our experience is otherwise.
In one matter under section 324 IPC, Lord, the state had withdrawn the case without notice to the complainant. And when notice was ordered to the complainant, she did not consent for withdrawal, and she wanted to pursue. On that count, the petition was dismissed, but the High Court said that when there is a withdrawal by the state, the victim cannot have any locus stand.
Exactly.
No, I think that there is some change in the Karnataka matter where the captain stays.
Abdul Karim.
And thereafter, even the Supreme Court recently, when the Kerala government wanted to withdraw that assembly issue, court said no. When evidence is there, public property is being involved, you don't have the right to exercise the power. The courts are right in dismissing the application for withdrawal of permission.
Because even the prosecutor has to act fairly and without any personal interest. He is not a mere name lender of the state.
No, what normally does is they only give the government order and say that permission may be granted. They're not even given reason as to why
they don't apply their mind.
Yes.
Sir, now can I request Prem to do the concluding remarks as well, now that he has started the initial setting of the stage?
Post-operative suture.
Yes, Prem, over to you.
A great articulation on this particular topic. And as we know that this criminal jurisprudence, it has always been accused-centric. And we want it to be victim-centric. Now, with the advent of this philosophy of victim compensation, the purpose is not to avoid damages akin to those cases of tortious liability, but you are giving solace by way of compensation, and that too out of the public purse for the injury which is sustained, whether or not the offender is brought to book. So now you have a new stakeholder who is ushered in by means of the Criminal Law Amendment Act section 2WA of the CRPs. Now, I think Professor Rose was telling about Subhra Chakravarti. Now, that was a case where in the Supreme Court, it's a case between the husband and wife. When Bodhisattva Gautam, he was, in fact, was the appellant there.
Exactly.
The wife was put great sufferings, inclusive of forcing abortions, multiple abortions. And that was the case in which the Supreme Court ordered for interim compensation, 1,000 rupees monthly to the victim, till the case continues. This was the case which the Supreme Court invents the concept of interim compensation. Now, as Justice Ramkumar and Justice Ramakrishnan, and of course, Advocate Virupaksha Gowda also pointed out, now the prosecutor is given the role. True, you have, in the 2009 amendment, you have had a proviso to section 24 clause 8 of the CRPs. Now the latest ruling, 2020, Rekha Murarka, you see the Supreme Court holding that though under 24 clause 8, the victim can engage a private counsel to assist the prosecution, the counsel not given the right to make an oral argument, or he cannot cross-examine a witness. Now, I would say that this judgment, it would result in a breach of faith as far as it limits the participation of the victim in its justice delivery mechanism by totally confining or restricting the scope of a private prosecution as a workable solution. Now you can see the highest court of the land, the Supreme Court. Nirmal Singh Kahlan, that's a 2009 decision, AR 2009 Supreme Court 984, where the Supreme Court explicitly enunciated that fair trial is a fundamental right under Article 21. And the realm of fair trial that includes fair and effective opportunities which are permitted by law to prove innocence or otherwise. So in my humble opinion, Rekha Murarka, it will be a total denial of access of the private prosecution, which is against or rather run counters to Article 21, because it violates the fundamental right, and especially Article 21, which is the very heartbeat of our Constitution. And as Professor Rose had mentioned, restorative justice for the accused and reparative justice for the victim, of course, that's what is being needed at this present moment. Now, she was pointing out the Bhagalpur blindings, Khatri's case. True, a victim of a crime can have sufferings of many various types. So the compensatory part shouldn't be merely financial. You should be receiving, apart from the financial help, you should be receiving the psychiatric help, the medical help, your protection against secondary victimization, social support, because you are going to live in a society again, and to ensure that the life of the victim isn't defined by the crime as against that particular victim. And we see the ground reality is that the victims, they are overlooked in misplaced sympathy for the criminal, because ignorance of any role of the victim, it is not only the denial of justice to that victim, it would also amount to negating the very rule of law, the very fundamental of democracy and the constitutional mandates. And I would say, I would conclude by saying just one thing. Madam, you were referring to that 2020 decision in the District Collector Alappuzha versus DLSA.
Yes.
The court, Kerala High Court, goes on to hold that Section 357A, that was substantive law, right?
Yes.
Now, there I have a slight, I would disagree with that. Why? Because you can see there's a constitution bench decision in Executive Engineer versus Denkanal Minor Irrigation Division of Orissa. That's a Budraj decision, the 2001-2 SCCA, page number I don't remember. Where the Supreme Court says substantive law is that part of the law which creates and regulates a right, in contrast to what you can call as the adjectival or the remedial law, which provides for a method of enforcing that right. I think this Kerala High Court judgment to that particular point, you call it a substantive law, that runs counter to this constitution bench decision. Anyway, that is indeed a very wonderful lecture. We got a lot of learning. Thank you so much.
I will add one more ground to your point. That is,
Yes,
by a private lawyer conducting prosecution, it overlooks the definition of the word prosecutor. Public prosecutor includes a person conducting the prosecution under the directions of the prosecutor. There is a beautiful judgment by Justice Subramaniam Poti, wherein his lordship said that a private person conducting the prosecution is like a senior's junior. Instead of the senior, junior conducting the case, you can't deny him the right to cross-examine, the right to argument, etc. So way back in 1978. That should be the meaning of the word prosecutor, not merely the state-appointed prosecutor.
In fact, in 2015, there was another judgment in the Dhariwal Industries case, which draws a subtle distinction between 301 and 302.
Yes.
That also was slightly overlooked.
the way the subject was analyzed today, as we come to the end of the 263rd session. First of all, let me thank Professor Dr. Rose Varghese. Ma'am, thank you for accepting our invitation and again addressing this platform. We do look forward to see you quite often on this platform. Thank you very much. This is Ramkumar sir, this is Ramakrishnan sir, Virupaksha Gowda sir, and all of you wonderful participants for a Saturday evening well spent on a topic of very, very current relevance. So once again, thank you all, and till we meet again next week, please do take care and stay safe, and let all the variants of Omicron or Corona stay away, and let us have different variants or different thought patterns in this legal empowerment sessions. Thank you very much. Please do take care and stay safe.
Welcome.